Hello and welcome to the Arbitration Conversation. In this webisode, we're going to talk about investor-state arbitration and mediation. And we have the pleasure of a true leader in the area, a leader in international arbitration and mediation. In fact, I had met him last year at the AAA offices in Chicago and right away knew that he is a rock star in the area. So this is a delight. So thank you so much for being here. His name is Wolf von Kumberg. Wolf, thank you so much for being here.
Thank you so much, Amy. It's a pleasure to be here.
So maybe you want to start just by telling us a little bit about your background.
Yeah, well, it's quite international, actually. I'm Canadian by origin, but I've spent about 25 years primarily working out of Europe for several multinational companies as their in-house counsel. So my role was really an international role for several US companies. And in that role, I played, I think, an important part in their dispute management, dispute resolution side. And so over the years, that's very much where much of my attention has been within those companies dealing with their international disputes.
So also explain a little bit about your background and being, you're both a lawyer in London and Canada. So I imagine you've spent quite a bit of time in many different parts of the world.
Yeah, so absolutely. As I say, I originated from Canada, so my first legal degree is actually from Canada, and I was qualified there. But I moved to London probably about 25 years ago now, and qualified as a solicitor in England, and so practiced there, as I said, primarily as in-house counsel, but yes, very much becoming involved in the British legal scene as well.
But now, specifically with investor-state dispute resolution, how did your work with Northrop then bring you into that area of dispute resolution?
So yeah, I was with Litton Industries and then with Northrop Grumman, both very multinational and dealing with projects all over the world, actually. And as I said, I mean, one of the areas that primarily occupied my time was the dispute resolution side of it. Not only when disputes actually arose, but from the planning of our projects and looking at the best dispute resolution mechanisms to build into our contracts. Our international contracts for many years had arbitration clauses where we could possibly negotiate those with the counterparties. And so arbitration became very much a standard for us to utilize in our international work. I actually became very interested in arbitration. Our arbitration work, thought that I should actually qualify as an arbitrator, which I did in 1998. I became a fellow of the Chartered Institute of Arbitrators. And so that helped a lot in my day-to-day practice as well with the companies. The other area I then became very interested in was mediation, because certainly on the US side, these companies I worked for were utilizing mediation increasingly. And so I thought I should also learn a bit more about mediation. I qualified as a mediator in 2001 with CEDAR in the UK. And so that helped a lot as we tried to build mediation into our disputes clauses as well as arbitration. There were parts of the world where mediation simply wasn't known. It was very difficult to even have people look at building that into the disputes clause. But increasingly, certainly towards the end of my corporate career, which was in 2015, more and more I would say jurisdictions were looking at mediation and we're accepting mediation clauses as well as utilizing mediation. So I would say that at the end of my corporate career, both arbitration and mediation were quite widely accepted.
So I wonder, in kind of digging in a little bit more from a dispute system design aspect, because I'm thinking specifically about investor state and the kind of disputes that are involved. Do you think about the clauses in terms of dispute system design and kind of fitting the form to the fuss, meaning crafting your process maybe with med-arb or just mediation or just arbitration? What was your thought process as you kind of went through your career?
Well, you know, when you're dealing with states, it's quite a different circumstance than in a pure B2B type situation where the parties are really interested in the commercial aspects of the deal. You know, states have a lot of other considerations when they're doing something commercial, even though it's commercial. And so you have to be able to craft the terms of the agreement so as to acknowledge at least, you know, some of those concerns that states have. I think most states that we dealt with understood that we would be reluctant to actually litigate in their courts as a dispute resolution mechanism. And in most places, we were able to agree arbitration, and often a venue then for the arbitration that was a neutral venue. So I think, you know, many states understood that. I mean, there were some circumstances where we couldn't do that, but that's what we always aimed to do because it was one of the risk mitigators then for a particular project. And so, yes, so we would certainly be looking at that as we're negotiating the terms of the agreement. As I said, I mean, where we could later on, we would also start talking about mediation and whether mediation might not make sense with states, and this gets to the investor state arena of dispute resolution. I mean, states themselves traditionally, I think, have been reluctant to mediate. I know in my own experience, and we, you know, wherever we had issues that arose with contracts, even trying to negotiate settlements with states sometimes would become difficult. Not so much that states, you know, don't want to engage in that. It's just that the mechanism, the internal mechanisms that states have to resolve issues, particularly if it's something where they have to spend additional budget. There's a whole bureaucracy around that, which makes it then difficult, you know, and in a B2B situation, you know, people can be much more pragmatic in how they try to resolve something. For a state, that's much more difficult. And that gets into some of the issues around investor-state mediation and how that actually works.
So does the Singapore Convention have any applicability here in allowing for more mediation, perhaps?
So the Singapore Convention, I think, plays a number of interesting roles with respect to states and in mediating with states. Because first of all, it is a treaty. So the states that adhere to it actually are coming to it willingly, recognizing that mediation is an acceptable forum through which disputes can be resolved. Now, you can say that, well, they're doing that for their commercial parties, their own citizens that are involved in cross-border commercial activity. But by the very fact that a state recognizes that mediation is something that can be utilized and signing up to it as a state, that already indicates a certain trust in the process itself. And so much like the New York Convention, which deals, of course, with arbitration and the enforcement of foreign arbitral awards, the Singapore Convention, which deals with the enforcement of cross-border mediated settlements, is also a recognition by the state that it itself, you know, can utilize this as a mechanism to resolve its own disputes. And it gives mediation a lot of credibility. And so the idea is, and I think over time, much as with the New York Convention, states will also utilize mediation more to resolve their own disputes. That's certainly the thought
Yeah.
process.
No, that's a really good point. I also think, a lot of research suggests that when parties have a say in the settlement as part of a mediation, it becomes more, they're more likely to abide by that agreement because they felt more ownership perhaps than they would of a third party decision maker imposing something on the parties. So that has some promise.
Well, I think,
I wonder your thoughts on that. Where do you
yeah.
see the future?
Well, I think, Amy, I mean, you've sort of put your finger on it here with respect to states. And, the whole area of investor-state arbitration is an interesting one because, this has really developed over the last 60 years or so, largely through the World Bank and ICSID. So ICSID is the body within the World Bank that deals with these international disputes, commercial disputes, and investor-state disputes in particular. Really that developed as a system whereby states could arbitrate with investors. The previous system had really been, the state and state would try to negotiate where an investor might feel that they'd been done wrong by a state. But through the ICSID process, it really developed into a situation where states were willing to allow arbitrators really to make a determination as to the rights of the investor within their state, which is an interesting concept, that they were giving up some sovereignty actually with respect to those decisions. And for many years, states would generally abide by these arbitral awards. Interestingly, if you look at the statistics of ICSID, you'll find that in fact in more than 50% of the cases, it's the state that was successful against the investor rather than the other way around. There's a concept that investors tend to be successful, but that's not actually the case. However, over the last probably decade or so, and certainly over the last 5 years, there's been a lot of pushback by states, by the EU in particular, against arbitration in the investor-state context. Because there were a few erroneous awards with respect to states where it was felt that the arbitrators really didn't consider sufficiently the sovereignty aspects of the state, and that the awards themselves were such that they called into question the whole system of investor-state arbitration. Now, you can argue whether that's correct or not, because obviously once you agree to arbitration, then it's something that is part of the form of arbitration, that the arbitral award is generally final, unless there's a limited number of ways to reopen it. But I think that's particularly what irked some of the states. And the EU. I mean, the EU criticized arbitration as being, private courts, and really has gone out of their way to eliminate, certainly within the EU, any of the bilateral investment treaties that still existed between EU states. And they've gone so far as to basically try to ban them. So that's an interesting development. You also see, just an attack on the whole system by, some institutions. I mean, the Columbia University has its program on sustainable investment, and they came out earlier this year after COVID-19 basically to ask for a moratorium on investor-state arbitrations because they felt that states, of course, had to take some extraordinary actions because of COVID-19, which would affect certainly investments. But because of the circumstances, it wouldn't be fair that states would then would have arbitral proceedings brought against them because of COVID-related actions that they had to take. So they just called for a moratorium. Now, you know, that's of course not something that's binding, but it just indicates some of the strong feelings around that.
Yeah, no, I mean, as that actually is a great segue into the next question I was going to ask is sort of how COVID-19 has played into the equation with these cases. It sounds like it definitely played in the equation.
Oh, it's definitely played into the equation. And I think, you know, we're yet to see, but I think there will be a large number of cases that come out of COVID-19 related actions by governments. Certainly, you know, there will have been situations where investors and the investments have been prejudiced in some fashion, but that's because of the necessity of the situation. At least that's what the state would argue. So and that really is a segue into mediation. So everything we've just said about the attack on the arbitration system that's developed around investor-state disputes leads to, you know, what are the alternatives? And in fact, that's what the EU was also looking at, is what are some of the other alternatives that can be used, perhaps in conjunction with arbitration, but what are the alternatives? And certainly mediation started to look like a potential tool that could also be utilized in investor-state, in the investor-state arena. I mean, if you talk to people, you know, and I did 5 years ago about this, they would say, particularly practitioners in the firms that practice a lot in this area, they would say, you know, it just won't work because states simply won't want to mediate. So there's no point even in trying to raise it because there are just too many obstacles for states to mediate. It's interesting, over the last 5 years, that's really changed a lot. And it's been, I've got to say, because I've worked a lot with the Energy Charter Treaty Secretariat, so the ECT, which has about 54 member states in it. And that whole effort around mediation was driven by states. So the states wanted to see whether there was an alternative in mediation, whether that could work. And so there was first a mediation guide that we wrote for the ECT. And then the second development was really a model framework that states could incorporate, which would allow them to deal with disputes through mediation or through settlement agreements. And so that model is actually a good one to hold up as a way for states to deal with things like authority, things like dealing with the mediation process, you know, who's appointed to attend, what authority do they have, and how do they actually deal with a potential settlement? Because there's a lot of concern, of course, in some states around corruption and ensuring, and particularly the public servants are concerned about being then blamed for a potential corrupt settlement. And so they want to protect themselves. So this framework that was developed tries to deal with those aspects of it. And it's drafted in such a way that it can be incorporated by any kind of state, I mean, any kind of government.
That's really great. And is that publicly, I mean, it'd be great to
It
direct
is
the viewers.
available.
It's publicly
Both, yep.
available?
It is. So both the mediation guideline and also this protocol, the model protocol, it can be found on the ECT website. So if you go to the ECT,
wonderful, that's a great resource.
Right. Yeah, they're very interesting. And the other thing is ICSID itself. So ICSID has, in addition to arbitration under its rules, something called conciliation, but it's not
Mhm.
it's not mediation at all.
Right.
Conciliation is really an opinion that a non-binding opinion that is rendered, and it's not being used very often because it really replicates the arbitration process, except it's now binding. And so few states have wanted to, and investors have wanted to invest in that, so they simply haven't gone down that route. But there are now draft mediation rules that ICSID has published, and they're hoping by the end of this year that those will actually be promulgated. So ICSID itself has seen the need for at least there to be a mediation possibility within these types of disputes. So that's gone a long way to give mediation credibility within investor state.
Well, this is great. Yeah, I mean, lots of information here. I didn't want to take up too much of your time this afternoon. I know you've got lots to do, but I really appreciate this. It was a great encapsulation of sort of how things have developed with investor state. Lots of good information and resources. Truly, truly thank you for taking this time today. So I appreciate it.
Very happy to do so, Amy. Thank you.